Good afternoon, good evening, morning, all, wherever in the world you may be. As Ben said, my name is Ashika Singh. I'm at Debevoise in Plimpton, and I'm delighted to be bringing together today a group of very distinguished panelists to discuss enduring issues related to the continued operation of the Guantanamo Bay detention facility and the men who remain detained there, inspired by the film The Mauritanian. So Guantanamo is something that may have fallen off the radar screens a bit for most people over the last 4 years. But with President Biden declaring a renewed intention to close the facility, and with the release of this excellent film earlier this year, we thought now would be a good time to increase the visibility of this issue and focus on Guantanamo and the men who remain detained there. As some of you, I'm sure, know, 40 men remain detained there. The average length of their detention is now 16 years. The first detainees were brought to Guantanamo in January of 2002. Of the 40 who remain, 11 have been cleared for transfer home or to a host country. 3 of those men have been cleared for transfer for longer than a decade, and yet they remain. 12 detainees are currently facing active or proposed charges before the military commissions, and the remainder are designated only for continued detention. So with that brief refresher on the current state of things, I'd like to introduce this extremely distinguished panel, who I'm delighted we're all able to join us today. First of all, we have Nancy Hollander. Nancy is a partner at Friedman, Boyd, Hollander, Goldberg, Urias, and Ward in Albuquerque, New Mexico, and also an associate tenant at Doughty Street Chambers in London. For 11 years, she represented Mohamedou Ould Slahi, who is featured in The Mauritanian. He is The Mauritanian. She eventually secured his release from Guantanamo and facilitated the publication of his memoir, Guantanamo Diary. In addition to Mr. Slahi, Nancy represents another individual detained at Guantanamo, Abdrahim al-Nashiri, for whom she, along with the Justice Initiative, has won 2 cases in the European Court of Human Rights. Nancy, thank you so much for being here with us today. Next, I'd like to introduce Judge Stuart Couch. He's currently a judge on the Board of Immigration Appeals. He was appointed to that position in August 2019 and became an immigration judge in 2010 after 22 years of active Marine Corps service, including as a senior appellate judge on the U.S. Navy Marine Corps Court of Criminal Appeals from 2006 to 2009. From 2003 to 2006, he served as a senior prosecutor for the Office of Military Commissions for select detainees held at Guantanamo, including as the lead prosecutor in Slahi's case, and in the case of Salim Hamdan, as well as OMC liaison to Solicitor General Paul Clement when the Hamdan case was argued before the Supreme Court. So Nancy and Stu are, of course, featured in the film, The Mauritanian, as played by Jodie Foster and Benedict Cumberbatch. Played quite well, I think, although, of course, you can tell us what you think about that. The film, of course, tells the story of Nancy's client, Mohamedou Ould Slahi, who was held at Guantanamo from 2002 to 2016. And we'll get into more details about that later on in the program. Turning now to the rest of our panelists, Brian Egan is a partner at Steptoe & Johnson in Washington, D.C. From 2016 to 2017, he served as legal advisor at the State Department under the Obama administration, where I was fortunate enough to work with him because in my previous life, I was an attorney advisor at the State Department, where I worked primarily on Guantanamo-related issues for a number of years during the Obama administration. In that capacity, of course, he advised on all legal issues that impact U.S. foreign relations and managed the U.S. government's international law portfolio. He previously held a variety of other positions in government, including as legal advisor to the National Security Council and deputy counsel to the president. Brian, it's great to see you again. Thanks for being with us today. Next, we have Professor Ona Hathaway, who is the Gerard C. and Bernice Latrobe Smith Professor of International Law at Yale, where she also serves as director of the Center for Global Legal Challenges and counselor to the dean. Professor Hathaway has served as a member of the Advisory Committee on International Law for the legal advisor at the State Department since 2005, and from 2014 to 2015, she took leave from Yale to serve as special counsel to the general counsel at the Department of Defense. Hi, Ona, thanks for being here. Next, last, and certainly not least, we have Andrea Prasau, the Deputy Washington Director of Human Rights Watch. Andrea conducts advocacy before the US government in that capacity on global human rights issues, the particular focus on national security and foreign policy. Prior to joining Human Rights Watch, she served as a defense attorney with the Office of Military Commissions, where she served as assistant counsel for Salim Hamdan. She has also worked in private practice in New York, where, among other things, she served as habeas counsel for 10 Saudi detainees at Guantanamo. So very long and deep experience with many aspects of the Guantanamo issue for many years now. Thanks so much for being with us today, Andrea. So no further ado, let's just dive right in. I'd like to start here with first principles and talk about the continuing authority of the US government under both domestic and international law to detain the men who remain at Guantanamo. It's of course the 20th anniversary of September 11th coming up this September, almost the 20th anniversary of Guantanamo that's coming up next year, and yet these men remain detained there. And before we launch into that, sort of set the scene, I'd like to show a clip from the film that depicts the circumstances of Salahi, in particular, his apprehension and entry into US custody. So please bear with me. This worked before, and hopefully it will work now as I try to share my screen.
خليه والدتي.
عندك أنا ما هو شيء على بالتلفزة ليش يتيمس؟
ما أنا هلا ما هو شيء. كم من مرة الله ينعل عليك نفس الكلام. محفوظ ما عندي عنه أخبار. ما ظهر لي قاع عن بن لادن نفسه يعرف هو مناهي.
شوف بعد تفجيرات نيويورك الناس عادوا لا يتهبصوا كل حاجة يطيروا عليه والخلطة يختاروك تجابر معاهم ويسولوك. سمعت
اسمح لي صن بدل لا يشوكوا لي أمير خليجي.
شو يشتغل تربو تركب معي أنا وفدي.
لا نتفق بسيارتي.
أعطيني تليفونك أصلا. أوكي.
تركب وتعرفي لها شلون نقولها؟
لا قول لهم أنا عندي عمل. لو كانوا يحكميني ما يخلوني نطلبهم بودي. تخافي يا مامتي.
So there we see that, of course, that Mahamadou was picked up at home in Mauritania. The US government has consistently taken the position now across 4 different administrations that the men at Guantanamo are lawfully detained under both domestic and international law. And for the benefit of those in the audience who perhaps haven't been tracking these issues as closely, Brian, I'd like to turn to you first. Would you be able to explain the US government position regarding the legal basis for its authority to detain the men at Guantanamo, first under domestic law and secondly under international law?
Yeah, thanks for that question, Ashika. hello to everyone watching this. Thanks for joining us. So starting with U.S. domestic law, the U.S. Congress passed a statute in 2001 that's known as the Authorization for the Use of Military Force, or AUMF. And the AUMF authorizes the president to use military force against, quote, those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th, 2001. So the executive branch has used the AUMF, which remains in force somewhat controversially to this day, to authorize the capture and detention of detainees as part of the authorization to use military force. And the executive branch has construed the AUMF to apply to Al-Qaeda, the Taliban, and their associated forces. And this is a position over the course of the years that's been accepted by the courts in the United States and also endorsed by the Congress. As a matter of international law, the US position has been that the United States is in a non-international armed conflict against those responsible for the 9/11 attacks. Again, to include Al-Qaeda and the Taliban and their associated forces. And so thus, as part of that non-international armed conflict, the US takes a position that members of the groups who are part of the conflict with the United States can be captured and detained consistent with international law. So I'll stop there.
Thanks, Brian. I think it's just really helpful to have that basic framework in mind of what at least the U.S. government position is as we move forward with these, with the discussion today. So of course, the US government position has been contested from the earliest days of its implementation under the Bush administration. And the clip that we just viewed depicts the operation of this US government position in operation. So what you saw there was Slahi being picked up at home in Mauritania. The basis for this, according to the government, he allegedly swore bayat to Al-Qaeda when he traveled to Afghanistan in the early 1990s to support the Mujahideen. He was then suspected of the US of recruiting for Al-Qaeda and continuing to support them. He was picked up at home in Mauritania by local authorities in November of 2001, far obviously from any active battlefield, at least in the conventional sense of the term, and then handed over to US authorities, held in various other facilities overseas for months until he arrives at Guantanamo in August of 2002. And Slahi is, of course, far from the only detainee that was picked up and rendered in this manner. I'd like to turn to Ona now and just to discuss, do you think that this is a legitimate application of the US authority to apprehend and detain individuals on international armed conflict against Al-Qaeda, the Taliban, and associated forces, even under the US own theory of its authority? And if it was legitimate in 2001, 2 months after 9/11, is it still legitimate now as a continuing, as a basis for continuing to detain these men?
Yeah, great questions. So what this really turns on to in significant degree is facts. And the facts in particular of whether Slahi was actually directly involved in a armed conflict against the United States. And whether he was and whether he continues to be associated with a force that is continuing to be involved in armed conflict with the United States. So he, as you said, allegedly swore bayat to Al-Qaeda in the 90s. Now that was a Al-Qaeda that was engaged in a very different kind of conflict. This was not an Al-Qaeda that had attacked the United States. In fact, we were on the same side, as he points out in the film to the Americans. Yes, I swore bayat to Al-Qaeda, but at the time, we were basically on the same side. And so the challenge there is the fact that he swore bayat in the 90s sufficient to consider him to be a member of the Al-Qaeda that had taken down the towers in 2001? Was he currently engaged in the fight at the time he was picked up? As you said, he's far from the battlefield. Now, that doesn't necessarily mean that he couldn't have been directly involved. When, in modern age, one can be engaged in planning, coordination. The claim was he was engaged in recruitment. So if that if he was actively engaged in the fight, then that might qualify as direct participation in the armed conflict and therefore be sufficient, at least under international law, to qualify, and might also bring him within the scope of the 2001 authorization for use of military force that Brian mentioned. Those are contested facts, as I understand it. That was the argument the government made, but couldn't prove its case without evidence derived from torture. And so that was the reason that that ultimately he was allowed to leave Guantanamo. Is it legitimate to continue to hold people now that we're nearing the 20th anniversary of 9/11? I think there's a very, very strong case that the conflict that existed at the time the 2001 authorization for use of military force was enacted no longer exists. I mean, the US is withdrawing forces from Afghanistan, is ending all combat operations there. The Al-Qaeda has morphed and changed in significant ways since then. We're really primarily engaged in conflict against the Islamic State, which is a group that didn't exist at the time. So there's lots of reasons to think that there's not ongoing hostility sufficient to justify continued decision to hold people who were captured. Now, in many cases, as you said, the average like the time that they've been held is 16 years. So they've been out of the fight for a very long time, and it's not clear that the fight that they were picked up on still really exists.
Thanks so much, Ona. And you predicted my follow-up question, which was going to be exactly about the impact of President Biden's announcement that by 9/11 of this year, the US will have fully withdrawn for Afghanistan, what the impact of that might be on the US's detention authority in relation to the men who continue to remain detained there. If anyone else would like to weigh in on that, please feel free. Yes, Andrea.
Thanks. I just wanted to note, Ona said it's a question of fact. I actually think it's a question of law. And I think a more accurate statement is that most countries except the United States don't believe that international law authorizes the kind of detention that we've seen at Guantanamo. Once you accept there's legal authority to detain, of course, there's a factual question about whether or not these detainees qualify. But prior to 9/11, it was pretty widely accepted that there was no authority for ongoing detention without charge of persons captured during a non-international armed conflict. The US has consistently disagreed with that, but it did, and I think still largely stands alone in that assessment. And the international community has generally accepted at this point that Guantanamo is this ongoing aberration that no one wants to really discuss and engage with, so that international law, international human rights law can remain relatively clear. It's an area that no one is happy with in terms of the clarity of the law. There are valid arguments, of course, and I've had these arguments with some of you over the years, but I don't think it is as clear as anyone in the US government would put forward, that as a matter of law, the US ever had the legal authority to detain people for more than the brief amount of time they would have had on any battlefield to capture and process someone.
Thank you so much. Definitely a very important point to bring to the fore. I don't know if Brian or Ona, you want to respond to that from the US perspective, or if we think we've sufficiently beaten this horse and should move on.
Well, speaking from my own perspective, I don't work for the US government at this point, but Andrea is quite right that the US position is controversial in this area, as is, for that matter, the US position on the scope of the armed conflict, which used to be called the global war on terror. But the US position is that there is a worldwide non-international armed conflict involving Al-Qaeda, the Taliban, and associated forces that, to say the least, is not widely accepted by others in the international community either. So certainly is true that these issues are controversial. I do think the US has been fairly consistent in articulating its approach to these issues. On your follow-up question, Ashika, on what happens when we withdraw, if and when we withdraw from Afghanistan, my prediction is that the US government may continue to take the position that, notwithstanding the withdrawal of our troops from Afghanistan, the non-international armed conflict continues. That will be even more controversial than it is today, but I think it's certainly a possibility that the US could continue to articulate that position, because without that position, the continued detention of folks at Guantanamo becomes even more attenuated for the government, I would say.
Can I just jump in real quickly on that point? I think that that's exactly right. And one thing I would, if there's anyone from the Biden administration watching this, encourage them to seriously think about is whether it may not be the greater part of valor to not make those arguments. And one of the big questions that an executive branch is going to face, that the Biden administration is going to face, just in the way that the Obama administration did, is if we want to close Guantanamo, how do we do that? And one of the big problems that the Obama administration ran into is that Congress basically quickly put in place legislative prohibitions on transfer of Guantanamo detainees to the United States and made it very, very difficult to transfer out, even people who are cleared for transfer outside the United States. As you said in your intro, there are many people who have been cleared for transfer who've been sitting there waiting for a very long time to leave. And one way that the Biden administration could do an end run around all of this is stop defending the detentions and stop making these arguments. And if you did, then a court would force you to release these folks. And that might be the easiest and fastest way to clear out Guantanamo. Do I think that that is what they will do? Probably not. Because government lawyers hate to give up any shred of an argument, particularly one that they've held to for a long time. But is there a really good reason for them to think seriously about it? I really think so.
Absolutely. So I'd like to turn now from legal principles to the realities on the ground at Guantanamo. I think the film does a really compelling job of illustrating the difficulties of litigating Guantanamo-related cases on behalf of the detainees, but also on the prosecutorial side as well. Just the pure logistical difficulties of getting to the base, getting access to your client, concerns about unmonitored access, classified evidence. I wanted to show another quick clip from one of the many scenes in the film that illustrates some of these issues. So if you will bear with me, let's see if I can make this work again. All right, I'm sorry, it's looking like it may not want to play, so let's just leave this sitting here to see if anything happens while I just turn to, so what this was about to show, which I'd wanted to ask Nancy about, was when she and her co-counsel go down to the secure facility that was in Crystal City. I actually haven't been involved in a while, so I don't know if that's where it still is, where you have to go in. There's this entity called the privilege team that is supposed to be independent from the prosecution or the defense and the government side, that reviews, for example, all the materials coming out of Guantanamo. If your client writes to you, they have to review it for privileged material, redact any information, and they pass it on to you, or any files also that you receive from the government. You have to travel down to the secure facility and go into a room and review the files there. So Nancy, I believe that your representation of Salahi was your first experience representing a detainee at Guantanamo. And I'm just really curious what you made of all of this and how you navigated these hurdles to still provide your client with vigorous representation. You, of course, first won a favorable decision in his case from the district court in his habeas case, and then ultimately secured his release via the periodic review board process. So just really interested to hear your take on all this.
Well, thank you. And thank you for having me. I had previously had clients who had evidence that was classified at the secret and top secret level, an espionage case, also the Holy Land case, which involved classified evidence. So I knew how to deal with that. What was different about this case was having to go to the secure room. So what would happen is he would write us a letter, or we would take notes there, and it would get sent up to the secure room unopened. And we had an opportunity to either have the privilege team review it and release it either in unclassified or protected manner, which we could have on our sent to us, or we could go there and read the classified version. I never wanted to have a letter go to the privilege team that I had not first read or that someone had not first read. And after a while, Art Spitzer at the ACLU in Washington, D.C. signed on primarily for the purpose of being able to read those letters and over the phone tell us, yes, it's okay to send it, or maybe you should read this one first. And generally we sent them on. Now, then they had something called protected status. And I don't know, I kind of think they made that one up, but maybe someone would disagree with me from the government. But it basically said you could read it, you could talk about it within your team, whoever had signed the memorandum for the classified evidence, but you couldn't show it to the press. And that became a big issue, obviously, because we wanted this book released, which were all letters that we received over the course of a year. We wanted it released, and the government fought us and said no. And we argued, often arguing that the public is maybe the court of public opinion may be the only court he'd ever get, which are words from a Supreme Court case involving a lawyer named Gentili. But we did have a lot of redacted material. When we finally got the government's factual return in 2008 or 2009, it had so much that was redacted that we had to consistently file motions to compel and get a little bit more at a time. And the other thing that happened, which was significant, was we knew about Ramzi bin al-Shiba, as the film shows, but we asked for the circumstances documents. In other words, the documents, who did he talk to and under what circumstances? Because by that time we were pretty clear that he had been tortured. And rather than give us that, the government just said they wouldn't use any of it. So they really had a very narrow issue by the time we got to court, which is, did he ever withdraw from Al-Qaeda, whatever that means in a civil law situation? And the judge said, you know, you don't have evidence against him, he's to be released. But the other thing I wanted to say, if I can add one more thing, is the Obama administration did two things. First of all, it appealed, and maybe Andrea knows the answer to this, but I think it appealed almost every habeas case that was won. 70% of the habeas cases were being won at that time. And there were a couple juveniles it didn't appeal, but mostly it appealed them all. Well, if it wanted to close Guantanamo, it could just have let those decisions stand. The second thing that Obama did was, if you'll remember the Nigerian guy, I don't remember his name, but he was flying over Detroit and he tried to light his underwear on fire and he got caught. And allegedly he had been trained in Yemen, although the Yemeni who trained him was someone who was raised in Las Cruces, New Mexico. So Obama said nobody goes home to Yemen. And that involved a lot of these detainees. And those two acts by the Obama administration severely limited the number of people who could get out of Guantanamo.
Yeah, completely. And that remains an enduring problem, I think. I remember from my involvement in the transfer process. I mean, the biggest issue the special envoy had was trying to find third countries that would host these Yemeni detainees who were cleared for transfer. And of course, as you can imagine, it's not an easy process. And then there's all sorts of assurances that have to be negotiated in terms of their security threat and their treatment in the other country. So it's a great point, as you mentioned, that the continued fight on these habeas cases is certainly something that threw a wrench into the works.
Right. Mohamedou spent 6 more years in that prison as a result of that decision by President Obama to appeal, and the appellate court remanded the case. The district court never took it again, even though we filed lots and lots of motions. The ACLU had joined us. We all filed lots and lots of motions. Everybody did. The district court sat on those cases. I don't know why, but I think it's because they were afraid of going back up to the Court of Appeals and getting decisions that had been remanded the first time reversed the second time, which would have been worse. But that decision cost 6 more years. And at that time, in 2009, 2010, Yemen, was a place where people could have gone back to. Now that's more difficult. But I was in Yemen in 2009. People could have been released there then. And those guys, many of them are still there.
That's right. I wanted to turn to you now, Stu, because I believe Slahi's case was also the first military commissions case that you were assigned to after you joined OMC in August of 2003. So would be interested in your thoughts from the prosecutor's perspective. The film, it does a good job of showing the difficulties that even you faced as the lead prosecutor in what was supposed to be a death penalty case in obtaining the underlying records of Slahi's interrogations. What did you make of that at the time? And when did you start to suspect that something wasn't right?
Well, Ashika, thank you very much for having me. And real quick, I do need to give a disclaimer because I still work for the Department of Justice that I'm here in my personal capacity. It's my day off. This is all about a former life of mine. So none of what I've got to say here should be attributed to the Department of Justice, the Executive Office of Immigration Review, or to determine how myself or another immigration judge might decide a particular case. So with that disclaimer, I think, let me do a little bit of a run up to that question. The practitioners such as myself that are involved in military commissions, we all come from the military justice environment. And I think that was, what was interesting to me was with the Hamdan case was how that really queued it up. I think there was a disconnect between the ex parte querying cases and then how military justice circa 2001 actually was practiced. And the chief difference is the advent of the Uniform Code of Military Justice. So as myself, a prosecutor coming into this, I had been prosecuting military justice cases, high profile military justice cases. And so I kind of brought that with me. And I was quickly disabused of that notion that what might have flown in a court-martial environment wasn't really going to fly in a military commission. There's a snippet in the movie when and by the way, Nancy and I, we've become close friends involved in the movie, but we really didn't overlap at all in our respective roles in Slahi's case. Mine ended in 2004. In June of 2004, and I think hers picked up a couple of years later. But there's this interesting scene in the movie when they're having a beer in the airport at Guantanamo, and my character says, I want you to have open discovery, and that's so that when I beat you, I don't have to hear about it. I don't have those appellate issues. That's actually a reflection of military law that's enshrined in the Uniform Code of Military Justice is open discovery. And I've been a state prosecutor. I've been a federal prosecutor. And I will tell you that the most open file discovery is in that military justice context. So that was one of the things for me that was hard to sort of to go towards, let's call it statutory discovery, but not even that. I mean, the standards that we had when I came in 2003, it was all evidence that's probative to a reasonable person. That was the standard of admission of evidence, and that proved to be a two-edged sword. Let's put it. The other thing I found as a prosecutor, people that are uninformed about the military justice system have a sense that it's this rough justice, and we would hear that term thrown around, at OGC, up at DOD, and other places. Kind of this nature of I call it, bring the guilty bastard in here, let's give him a fair trial. People think that that's kind of how court martials work, and they really don't. My experience, I got burned by a military jury in a very high profile case in 1999. And so when I was looking at Slahi's information, I said, we can't leave anything to doubt. Actually, military juries are very discerning, and you just can't pull the wool over their eyes and just say, trust me on this. And so the first thing I learned about Slahi was that he and Al-Qahtani, we call him Big Al-Qahtani, he and Big Al-Qahtani were the two that we knew were subject to special projects. And when I started trying to ask the question, well, what does special projects mean? Everybody said, well, we really don't know. I can't tell you, but it doesn't sound good, And so that when I started looking at Slahi's evidence, and this was something I think one of the screenwriters wanted in the movie, it didn't make it. But from my perspective, I actually, and this is in Jess Braven's book, The Terror Courts, he goes on at length about this. When I started getting the intelligence reporting from Slahi, I said, I was reading it over and I said, at the very outset, he wasn't giving any information at all, but then suddenly he began to give a lot of information. And when I plotted it out over a graph, over time versus value of the information he was given. And I found this spike in the graph right around September of 2003, where he starts giving up all kinds of information. And so as the prosecutor, I wanted to know, why was that? Why all of a sudden did he start giving the information up? I know that he was subject to, your interview techniques at law enforcement, but was there more? And that's why it's not depicted in the movie, but I actually stumbled across a special projects interrogation in October of 2003 during my first trip to Guantanamo. And myself, I'd gone to SEER school, which is where these techniques came from. And so when I saw that interrogation, I knew, wow, man, that's violative. Whoever's doing that are probably committing violations of the UCMJ, maltreatment under Article 93 in their own right. And I knew from my training at SEER school that it was violative of the Geneva Conventions. I was later to learn that would give someone a toehold under the Convention Against Torture, Article 15, and that was going to be a train wreck for my evidentiary basis if that's how the information was being collected. And so that's that spike in the IIRs, and then observing that interrogation, that's when I realized we had a big problem. Last point I would make on that. I came back after that trip to Guantanamo. Obviously had some misgivings, especially in light of my treatment at SEER school. Went with my family to Barnes and Noble. My wife and my kids are smarter than I am, so they read the bound books upstairs, and I stick down around the magazine rack. And there was a magazine in October of 2003, the Atlantic Monthly, and on the front cover it says "The Dark Art of Interrogation." It was written by Mark Bowden. And when you go to read that article, it is a hypothetical of KSM's treatment. Well, this is when he was captured in Rawalpindi. And it probably this happened, and probably that happened, and probably another thing. And I've read all of Bowden's books, and I know that he's got incredible sources. And so I'm reading the article going, wow, we've been waterboarding KSM. And that's how we're getting that information out of him. And if that's they're having to do to get him to come out, and I had read his material out of TDX's, then Ramzi bin al-Shibh saying Slahi had helped them go to Afghanistan for training. I said, that's probably subject to the same thing. So those were my misgivings, and they kind of came based upon my own experience and based upon what I had seen with my own eyes and read in the magazine rack in Barnes and Noble.
Yeah, and that led you, of course, to make the courageous decision to decline to prosecute Salahi. I'm going to try one more time to show a clip because I think the scene is just so powerful, the way they show you come to that decision in the movie. Let's see if this works. And then I promise I won't, if this doesn't work, I'm not going to harass you with this anymore, but let's try one more time.
Sir?
Is this an inside in the warm issue or a standing out in the cold issue?
We can't prosecute Slahi. We don't have the evidence.
You have multiple signed confessions. What more could you need?
It was given under duress. Fruit from the poisonous tree. He spent 70 days in special projects, tortured. Not a single word he said is admissible.
No, that's what they're trained to say. AQ laid it all out in the Manchester protocols. The second you're detained, claim torture.
This didn't come from AQ, sir. This is coming from our side. Now, I read the MFRs. This guy, Captain Collins, some Navy reservist, he ran the program. Sleep deprivation, waterboarding, stress position, flat-out assault. He specifically threatened to have Slahi's mother shipped to Gitmo to have her raped by other detainees, and it is all documented. It's systemic, OSD approved. Donald Rumsfeld signed the top sheet. What's been done here is reprehensible.
I don't want to hear another word about detainee treatment. Your job is to bring charges. Let a judge decide what's admissible.
Sir, I refuse to prosecute this case. As a Christian, as a lawyer.
What makes you think you're any better than the rest of us?
I don't think I'm better than anybody else. That is the point. Now, we all took an oath to support and defend the Constitution. At the very least, we are miles away from that.
I think we lost the stream there, but what he says to Stu in that scene, or to Benedict Cumberbatch, I don't know if this really happened, probably not exactly how it's depicted, but he says, "You're a traitor," and then he drives away. Very dramatic. Stu, you can tell us the reality of what happened. I would be interested to hear, obviously, must have been a difficult decision for you to make, and the film hints at some of the consequences you suffered as a result of that decision. Would you be able to tell us a little bit more about that?
Well, I think as far as the scene, there's only, let's say there's two and a half points that are Hollywood, so to speak. One is that conversation occurred outside. I lobbied pretty hard that conversation would occur inside because it did. We were in a secure facility. The other reason was we were in the chief prosecutor's office, and he outranked me. He was a colonel. I was a lieutenant colonel. And I slammed, when he asked why I thought I was better than everybody else around there, I slammed my hand down on his desk, which is, that's probably an Article 91 violation right there. But they wanted to do it outdoors, a little bit more drama with the Pentagon in the background. The second point that is Hollywood, he did not call me a traitor, at least not to my face. I might have done another Article 91 on him and punched him out if he'd have done that. And then the half point, I think I brought up the Constitution. I don't know that I actually said what Benedict is quoted there, but everything else in that scene, that's how it went down. And I don't want to take too much time from everyone else. Really, the 3 points for me were this, and there's a much longer story about how I got access to the MFRs, but it was after I expected that the detainees were going to lie to us about their treatment. That's just the prosecutor's perspective, and having been through SEER school, that's sort of what I thought. But what turned me around was when I saw in our own government documents, this is what we did. This is how we conducted the interrogation. These are the techniques that we used. This is the ruse. I was like, they're going to see that stuff. So I had 3 points. Legally, I believe that we had tortured him, as defined in the CAT, the Convention Against Torture. Ethically, I believed that when Slahi did obtain counsel, and at the time I was dealing with the case, he did not. But as I explained, when he does get counsel, under my bar rules from the state of North Carolina, I got an obligation to disclose what I know, even though it might not be under the admissibility standards set by military commissions. I had an ethical duty so that the defense attorney could avail the protections of the CAT. of the Convention Against Torture for his client. And that position has since been adopted in the ABA model rules and in the North Carolina rules. It was the sense I had at the time, but later on it's been adopted, that special rule for prosecutors. And thirdly, and for me, and I just said as a legal matter, he's been tortured ethically. I've got to disclose what I know when he gets counsel. And finally, morally, as a Christian, what's been done to him is reprehensible. That's exactly what I said in person, and it's what I wrote in a memo. It's depicted in the movie. I had this epiphany at church on the Sunday before I went into the chief prosecutor's office on Wednesday, and that's how I sized it up. Everybody, we're all created by God in the image of our Creator, and we're due protections just on that basis alone. And I thought what had been done to Slahi violated that, and I just wasn't going to be part of. I did not believe that as an attorney of record, I could be in any way involved in presenting evidence derived from torture to incarcerate or even execute a man. Couldn't do it.
Thanks so much, Stu. And we know now, of course, that Slahi was not the only detainee subject to these techniques you mentioned. Khalid Sheikh Mohammed, we know about others. We know this also as a result of government disclosures. We had the 2014 Senate torture report. There have been numerous DOD internal investigations. And this issue of torture, the use of evidence derived from torture, accountability for torture, these have been fundamental issues relating to the detention of these men during what Brian said we used to call the global war on terror and the operation of Guantanamo for almost 20 years now. It is one of the key issues that have tied the military commissions in knots, although certainly not the only one. I had another clip. I'm not going to play it because I don't think it wants to cooperate now, but the film shows the scene when the chief prosecutor first brings you in to ask you whether you want to take Slahi's case, and he asks you, have you heard of ex parte Quirin? And you sort of say, what, the Nazi saboteur case from World War II, which is a case, of course, military commissions that were set up in World War II to try 8 Nazi saboteurs. And the chief prosecutor says, yeah, it's great, 8 Nazis, 8 convictions, 6 death penalties successfully executed, took about a month. Now we have a situation where almost 20 years, 8 convictions, 3 of which have been overturned, 1 partially overturned. And the 2 seminal trials, that of the 5 9/11 co-conspirators and of Nashiri, who's accused of masterminding the USS Cole bombing, have yet to begin. So what happened? I know this is a question that could take days to answer comprehensively, and there are a lot of nuances, a lot of different issues in the different cases, but I would love if we could sort of talk through what some of the key issues have been with the commission's proceedings writ large, maybe starting with you, Andrea, if you want to address that.
Sure, thank you. So I think, to put it simply, what happened is torture. Guantanamo was created as a form of torture, as a place for torture. Detainees were placed there specifically and deliberately out of the belief that they would be outside of the reach of US courts. And the military commissions were created to reinforce, cover up, and essentially make go away the problem of torture. The idea was a closed loop. What happened to these men would stay in this bubble. That is a position that the government continues to take to this day. And the reason that the military commissions in their 4th iteration, I think now, are not proceeding apace is because of torture and because the government continues to refuse to disclose information relating to their torture. At this point, that's largely with respect to mitigation cases because these are capital cases, not necessarily tied to the foundation of the evidence, but I can't speak meaningfully on that because everything's classified, so we don't even know. So I think it's just really important to remember that the entire creation of the legal system and the fact that these cases are proceeding in the military commission is for a reason. The reason is so that there would be different rules, so people could be prosecuted in a different way than the already, deeply flawed and racist and often ineffective US federal system, but a pretty robust system that needs to be fixed, but is, let me tell you, convicts terrorists about this quickly. So there is no issue that if pretty much anyone currently facing charges, and probably most of the people who were ever considered for charges, that if they were to be prosecuted in US federal court, they would probably be convicted very quickly. It's not hard to get a conviction for material support for terrorism in US federal court. People end up in really egregious conditions of confinement and would be there, at least as long as many of them have been detained at Guantanamo. But because the basis of the detention, which came, as we see in the film, came from torture, the information behind which most people were being detained, whether it was their own torture or someone else's, because the government has had a 20-year project of covering that up, it has been forced to use an alternative system, one in which it believes it could continue to keep that torture a secret. And here we are. And one of the things that I do as an advocate now is I work with a really great group called September 11th Families for Peaceful Tomorrows, family, survivors, family members of victims of the 9/11 attacks, who have been saying for years, have moral opposition to the military commissions and to the death penalty, but have been saying time and time again, we want some measure of justice. And if you keep using this broken system, we will never get them. And I think that it's really important for US policymakers to keep that in mind. You can reject the moral concerns if you want, you can reject the legal concerns if you want, but if your goal is to provide some measure of justice for the victims of 9/11, the military commissions in Guantanamo are never going to be capable of doing that.
Yeah, and this question of bringing them into federal court, I wonder, Brian, if you could comment on that, because I know under the Obama administration, it is something that was looked at. We got one detainee out to prosecute him in federal court, Gailani, before the congressional transfer restrictions came down. But do you think, even if it somehow again became possible, is it possible now, or are the evidentiary issues, just too difficult? And any other thoughts you might have on the question as well, I'd be happy to hear.
Yeah, notwithstanding Andrea's confidence that everybody would be convicted, I can assure you that my former colleagues in the Justice Department didn't share that view when they reviewed a number of cases exhaustively as part of the Obama administration's review of the situation in Guantanamo. And I think where I would agree with Andrea is the issue of torture would be front and center in an Article 3 case, just as it has been in the military commissions. As Stu said in the video clip, the fruit of the poisonous tree is an issue that would be as important in our traditional courts as in the military commissions. There has also been some other maybe more exotic and less important aspects of the commission's cases that have led to delays and lack of success, including in appeals to the DC circuit that several of you know much more about than I do, but things like the application of the ex post facto clause to some of the charges that have gone through Guantanamo, defects in the underlying statutory authorization. There are issues related to the nature of Guantanamo itself and the classified information, the special procedures that need to be followed that have led to delays. So I think that it's hard to find anyone who would say the military commissions have been a success or something we should continue. I'm not sure that an Article 3 path is really viable either at this point.
If I could just clarify too, Ashka, I don't think that a federal court would convict all of the 779 detainees who were once held at Guantanamo, or even 20 of them. That's because most of them didn't commit crimes, and there isn't any evidence that they did. But for those detainees who are prosecuted for crimes like murder, those are cases that the federal courts can and have handled in the past. Those are the cases where I don't believe where there is actual evidence of a crime that was on the books at the time it was committed. Those cases are dealt with in federal court very quickly. In Gailani, which was prosecuted in federal court, we did have a bad decision from a judge. It wasn't like everything was perfect. He said, oh yeah, all that time when the government was holding you doesn't count. So I don't think we should assume that federal judges would be particularly detainee friendly or anti-government. In fact, I wish that the story of Guantanamo was that the federal courts sort of saved us, but they didn't. The federal judges took a very long time to stand up for what was right. And then over the last, I guess it's been 18 years since they've had these cases before them, have gradually made often some good decisions. But certainly the history of the legal cases around Guantanamo is not a history of courageous federal judges standing up for the Constitution and international law.
If I may just jump in very briefly, I think that what Andrea said at the beginning is absolutely right. They kind of set this up as a kind of law-free zone. And then when they discovered they couldn't have a law-free zone, they sort of kind of patched it up, and we're left with this kind of mess of a system that's this kind of terrible handover that we're kind of stuck with. Had we gone the federal court route from the get-go, it would have been much better. You would have been much more likely to be able to actually process these cases. You would have also had access to conspiracy and material support charges, which are not law of war crimes and therefore can't be prosecuted in a military commission. And the conviction rate on those is over 90% in terrorism cases. And so had they gone that route, chances are that that we would be done with this by now. 20 years later, we would not still be dealing with people who are being charged of somehow being involved in a conflict that that relates to 9/11. Instead, we're sort of stuck here with the kind of impossibility of actually really bringing this to a close because these commissions can't actually manage to actually hold any trials, it seems, or are very slow in doing so.
Can I add something, Ashika?
Of course, Nancy, go ahead, please.
The other thing about the commissions is that hearsay is acceptable, and it's a bedrock constitutional rule in this country, the right to confrontation. Well, in Nashiri, for example, there aren't going to be any witnesses. We have killed several of them with drones. It's all hearsay, and they can't do it in federal court based on that hearsay. So there's a real question about whether this case could be tried and could he be convicted. Plus the other things that happen in the commission. For example, in the Nashiri case is a judge who didn't bother to tell anyone that he was negotiating with the Department of Justice to become an immigration judge, not Stu, of course, somebody else. And when that got to the Court of Appeals, they found what was an obvious, clear conflict and threw out all of everything he had decided for the last 4 years. So we're back to 2015. And the government had the chutzpah to walk into court and say, Your Honor, we want them all back. Just give us all of those back. And the court said no. Now, I think whatever judge we have at the moment who's done another bizarre case, getting this case, particular case into federal court and getting a conviction, leaving aside the torture, is really problematic for the court and for the government, and that's why they have to do it in the commission, because the commissions were set up to find people guilty.
These are all really excellent points. I wanted to talk a bit more about some troubling developments in the commissions as it relates to torture. But I see we have about half an hour left, and I did want to leave at least a little bit of time for questions. So maybe let's skip that now and we can circle back to it if there's time, because I did want to ask before we move to the questions, just to go around and get all of your thoughts on a way forward here. You know, we've discussed some of the really difficult issues with prosecuting the detainees who could be prosecuted, releasing detainees who are cleared for release. We haven't even talked about what's going to happen to the guys who are in either category right now. So looking ahead, given that the Biden administration has stated a renewed intention to close the facility, I would like to just ask each of you, what would you like to see happen under a Biden administration in order to do that? What would you like to see happen? And what do you realistically see happening in the next 4 years? And of course, I'm not just talking about closing the facility, because concerns have been raised in the past about the potential for creating a Gitmo North, where you just, you shut it down there, move them all here, hold them in another facility here, but you've just sort of imported the problem into the US and you still haven't done anything about just dispositions for the men who continue to be detained here. So maybe if we could go around, maybe Stu, can we start with you on this?
Well, to harken back to a scene from the movie Thelma and Louise, I think the administration right now with Gitmo is like that scene where they're both in the convertible driving pale mail towards the end of a cliff. The end of hostilities is coming. Okay, whether it's wrapped up in the nature of our withdrawal from Afghanistan or the crumbling of the support for the AUMF, So far, they've been getting a pass because we're in this period of hostilities. It seems to me every one of the federal decisions that I read starts off with that mantra, that they can hold, these detainees can be held until the end of hostilities. Well, and I would agree with Una. I think that's a fact. I think that's a fact question. And that fact is getting ready to come due. So I think they're going to have to do something for what little bit it's worth. And I defer to Nancy and to Brian that y'all know probably more about these cases than I have, because I haven't touched any of them since for 15 years now. I would like to see Article 3 prosecutions on all of these and let the chips fall where they may. I go back to something that Andrea said earlier. She's working with these family members from 9/11. And in my heart, as a former prosecutor, it's about justice. And the longer we delay these cases, the longer we mess around with this OMC experiment that we've been doing, that really strikes at the heart of justice. We've had victims' family members, victims that have gone to their deaths not knowing how these things were going to turn out. And that's wrong. If Article 3 courts are good enough for the framers of the Constitution to draw it up like that, we got to have faith and confidence in it right now. And I do. What I think we ought to do, I think we ought to, we take the 9/11 defendants, we take Al Nashiri, the president, I believe, under his Article 2 authority, can do this. You go down there, you clean out the brig at Quantico, you send everybody that's already in that brig down to Norfolk, you put all of these detainees in the brig at Quantico, and then you conduct Article 3 prosecutions in the Eastern District of Virginia, and we hope that Judge Brinkema gets a case because she did a damn good job on Massawi. Now, what's the downside to that? You could have an Article 3 judge that could rule as a sanction against the government that the death penalty is off the table. At this stage of the game, if I were a decision maker, that's one I'm willing to do. We have a saying in the Marine Corps, you got to deal with the where you are, not where you wish you were. And we got to deal with where we are. And that's why I'm a strong proponent of the Article 3 prosecution. What do you do with the non-prosecutable detainees? That's a really tough one. And we got a room full of international lawyers. So I'm not even going to try to get into that. I'll defer to one of you folks who are a lot smarter than I am on that point.
All right, let's go to one of the international lawyers then. Ona, do you want to go next?
I think that an important point that Stuart made, perhaps the most important point, is you got to deal with where you are, not where you wish you are, and this is that situation, right? We're in a really awful situation that's a result of so many horrible legal and moral decisions that have been made up to this point. And I think that leaves us with sort of no good options, so choosing among a bunch of bad options, really. I think I probably land more or less where Stuart does, which is prosecute everyone you possibly can in Article 3 courts, recognizing that some of those prosecutions may not be successful. And that's kind of the price that we pay for having made really bad decisions up to this point in terms of collecting evidence, in terms of obviously engaging in torture so that we don't have, in many cases, submissible evidence, but also recognizing that with material support and conspiracy now on the table in federal court, that does change the ball game a bit. It does allow you to use broader sets of evidence you might have to in trying to prove law of war crimes. And that has in the past been successful. What do you do with the non-prosecutable cases? I don't know enough about the specifics of them to know if they're truly non-prosecutable. I think in those cases, honestly, I think America can't live with a situation where we keep people indefinitely without ever charging them. And that's a bigger harm to the nation than it is to find a way to relocate them, to release them or transfer them to another party. Again, it's a kind of balancing the harms here. What's worse? When you're facing no good options. But if anyone else has a better option, I'm all ears.
Thanks so much, Ona. If anyone else would like to jump in to follow up on that, feel free. Otherwise, I can be the teacher and call on someone. Andrea.
Sure. I think it's important that we reframe things a little bit, because it's not a bad option to release someone who's been illegally detained for 20 years. What needs to happen for those people is they need to be released without security assurances because they haven't committed crimes, with a huge apology and a giant check from the US government. They were detained unlawfully, they were tortured, and they have been held, many of them, at the mercy of politics for the last 5 or 10 years. There is no justification for that. And they are owed an apology and they are owed amends, not just because it's the right thing to do, but it's also a legal obligation in some cases. And we're talking about maybe 30 of the 40 people who are there in those circumstances. And then, yes, there are people who probably may have committed very serious crimes and they should be prosecuted. That can mean negotiating plea agreements. And the detainee council are very open to that, and detainees are very open to that, as one might be after nearly 20 years of illegal detention and torture, even for people who might have committed serious crimes. But what we don't have and have never had in this country is political will. You know, you made a reference to the prosecutions in federal court. Well, when I woke up that morning when Eric Holder announced that he had made a decision to transfer detainees to federal court in New York to prosecute them, I knew that we had lost, because the announcement was not, this morning I transferred these men to federal court. It was over from that moment. And here we are. We have not had the political will from the Obama administration, certainly not from the Biden administration, to make tough decisions. So my recommendations are: release anyone who won't be prosecuted, negotiate as quickly as possible robust plea agreements to handle the rest of the cases, and make a firm commitment to never again detain people indefinitely without charge or trial. I don't have confidence that that's what this administration will do, but I don't know how they dig themselves out of this hole. And they better do it quickly because the midterms are coming.
All excellent points. Brian or Nancy, would like to go next?
I just want to say that I agree completely with Andrea. And it's exactly what I've been saying over and over again. Talking about this film is everyone who hasn't been charged gets released. End of story. They have to negotiate, as you and Brian know, places for them that are safe for them, and they then get to either go home or go where they'll be safe. And the rest we resolve in ways that are fair and provide due process to all of those. They may not all be resolved in the same way, but they have to get resolved. And we have to accept the fact that these people were tortured, and that we have violated the Convention Against Torture by not prosecuting the people who tortured them, which is an obligation if you know who they are. We do know who they are. And I would just add, we have brought a case in the International Criminal Court on behalf of Mr. Nashiri, which is a case where that court wants to prosecute them. Not that it'll ever get a hold of them, but I just think that's what we need to have happen. Whether there's the political will or Biden is willing to expend any political capital on that, I don't know. Obama was not, and I think there's no reason to think that Biden will, but he could get it done if he wanted to.
Thanks so much, Nancy. Finally, Brian, what do you think?
Well, if you're dealing with the Congress and the restrictions, I think one modest proposal, which I think could go a long way, would be to give the president directly the authority to make some of the certifications required to transfer folks. Right, for many years, that's laid with the Secretary of Defense. If the president wanted to take that authority, he is not able to, according to our OLC. So just give that to the authority of the president. He's the one who was voted into office. The buck stops with the president. He can make the decisions necessary to carry out the transfers that others have talked about, which I also support. I also think that Article 3 is clearly the way to go, and the chips will have to fall where they may. I just don't think it's sustainable to continue the military commissions process. The political side, and I was part of the Obama administration, so I lived through a lot of the things that I'm hearing about now. Congress plays a huge role in this as well. It's not just the president that gets to decide what to do. Even when the president wants to decide what to do, he is told that he can't. And so that has to be part of the calculation, is a constructive approach with Congress. It doesn't mean that you give up and don't spend any time on the issue, but figuring out, finding the allies who understand why this is so problematic for the United States as a national security matter, and finding an approach that would allow the things to be done that need to be done to close the facility. I think that pursuing this in a low-key manner, as it seems like the Biden administration is trying to do, is actually going to be helpful in that regard, to try to make this as non-political as possible and to get the job done, as I think Nancy just said.
Thanks very much, Brian. I'm glad you raised that, because we really haven't had a chance yet to talk about Congress and the role that it's played with these transfer restrictions that have been in place since, I think, the second year of the Obama administration in some form or the other. And for those not familiar, it's been a prohibition, an absolute blanket prohibition on transfers of the detainees to the United States. Brian mentioned the certification scheme, where the Secretary of Defense basically has to put his name on the line to certify that the person being transferred is essentially no longer a threat, or that their threat is being managed by the conditions that are being put in place around their transfer. And it's been a difficult thing at times to get the secretary to do, for obvious reasons. And maybe putting that on the president is a very good way to get around that. But we have about 15 minutes left, and we have 2 questions. So I think we'll certainly have time to address those, and then maybe time for some final thoughts, or to get back to the additional questions on torture I wanted to discuss in the commissions. So we have one question that's for Brian or Ona, which is about whether the following proposition is correct and relevant: that the Geneva Conventions neither authorize nor prohibit NIAC detention. Therefore, international human rights law is the operative international legal framework, and brings us to the problem that the US, unlike most of the rest of the world, denies that it has human rights law obligations in its conduct outside its own territory.
I can take a shot at that. I'm happy to have Brian jump in. Great to see your question, Gabor. So Gabor is really one of the world experts on this question. So he really should be on the panel. And he's written extensively on this issue. So there is, and you've already seen a little bit of the tension on the panel, this question as to whether international law actually permits detention in NIACs has been an ongoing fight, and by no means even today still fully resolved question as to whether international law permits or prohibits or authorizes, depending on how you think about it, detention in non-international armed conflicts. That's what we mean when we say NIACs. And as a result, to some degree of the ambiguity, and even the ICRC has been sort of back and forth on this question. It sort of seems to have a kind of split position that it's landed on, which is doesn't authorize detention in non-international armed conflicts that are fully contained within a single country, but does authorize it in what we call transnational non-international armed conflicts, which sounds like an oxymoron, but is what we're talking about. The conflict between the United States and Al-Qaeda is a transnational non-international armed conflict. And so international law, without going on further, is, I think, somewhat confused on this question, that there's at least a fair bit of difference of opinion among great experts on this question. What everyone is clear on is that it's not clear. So all that we have to work on is Common Article 3, which some argue suggests that it regulates the practice of detention, and therefore, because it regulates it, that seems to bless the idea that there is going to be a detention. Others say, no, that's the wrong way to think about it. It prohibits certain kinds of improper practices, and that is not thereby authorizing detention. That would be a context in which those unauthorized practices would take place. So it's a complex question, but I think the core of what Gabor is getting at here is, well, putting that to one side, or because that is an area of law that is that on which there's a great deal of disagreement. Obviously, the US government's position is that it can detain in the NIAC, and that's legally permissible. You then have this question of, where does international human rights law fit in? And the United States is an outlier in taking a firm position that international human rights law does not apply extraterritorially. Now, it has softened that position somewhat in 2014. It softened the position, allowing for agreeing that the Convention Against Torture applied in Guantanamo and on US naval vessels. And so that was an admission of application of the CAT to Guantanamo, but not, for instance, to Afghan bases, so Bagram or other bases, US bases around the world. And so didn't apply to alleged torture that's taken place at black sites and US bases and other places other than Guantanamo. Is that a problem? Absolutely, it's a problem. It remains a source of friction between the United States and the rest of the international community. Most of the rest of the international community takes the position that international human rights obligations apply wherever a state exercises what's called effective control. And so that would include bases abroad, so bases like Bagram. And there's another complex set of issues about whether you can have international human rights law and humanitarian law kind of operating together at the same time. There are ways in which they are compatible and, in fact, kind of identical. For instance, the prohibition on torture appears both in international humanitarian law and international human rights law. So it doesn't really matter which body of law you're applying. Both of them tell you you can't torture someone. They are different, though, for instance, on the question of whether somebody can be tried. So international humanitarian law provides that unless you've engaged in a law of war violation, you can't be tried for your action if you're involved in international armed conflict, not an IAC. Whereas human rights law says you have a right to a speedy trial. So those are places where there's some friction between the two bodies of law. The short answer to Gabor's question, though, is yes, it's a problem. It continues to be a problem. It will continue to be a problem. And I think the US should be looking, and the Biden administration should be looking at whether it can follow the Obama administration's steps in the direction of accepting some broader extraterritorial application of international human rights law, whether it might be able to consider expanding application of the Convention Against Torture, for instance, beyond Guantanamo to other bases where the US might be detaining people, and accept that, in fact, the Convention Against Torture's prohibitions apply in those places. And then another front on which there will be ongoing debate is whether the International Convention on Civil and Political Rights has extraterritorial effect. US position has consistently been that it doesn't. International position has consistently been that it does. And that's another source of kind of ongoing friction, I think will be a source of conversation throughout this administration. But I'm sure Brian has more to add since he worked in the thick of these issues.
I want to save time for some other things here too. I think Ona's captured it well. You know, the one thing that I would just want to keep in mind is that in the beginning, the US didn't even agree that Common Article 3 applied to the conditions at Guantanamo. And I think we wouldn't want to lose that in a debate about what the applicable rules are, because I think that that has changed the approach to treatment. You know, it has not made it perfect, but I think it's something that now the last administration recognized, as did the Obama administration at the end of the Bush administration was recognized too. So I just think we want to make sure we keep that baseline regardless of this debate on humanitarian law versus human rights law.
That's right. Thanks so much, both of you. So we just have one more question, which is directed to Stu and would be of interest, I think, to some of our younger audience, which is whether you recommend that younger judge advocates take a tour at OMC at this point, or would you deter them?
Wow, tough question. I've still got some people that I served with that are still serving at OMC, and I don't want to say anything that would besmirch them professionally or personally. I think every judge advocate who raises his or her hand and swears the oath and puts on the uniform, I go back to what a major told me in college: if you take the king's shilling, you do the king's bidding. And so if you are assigned to Office of Military Commissions, you go and you do your duty, uphold the Constitution, uphold notions of due process, and for whichever side of the aisle that you're assigned to, you do your best. Whether I would volunteer to go to OMC, Unfortunately, I would have to say no, I would not. As Forrest Gump would say, that's about all I'm going to say about that.
Thanks, Stu. I think your perspective is still really helpful and much appreciated. We do have a few minutes left, so I just wanted to quickly circle back to talking a bit more about some of these new developments in the military commission's proceedings regarding the question of torture. So in May, a sentencing agreement was reached in the Majid Khan case. For those of you who may not be familiar with the case, Khan was detained in 2003 and tortured at a CIA black site before being transferred to Guantanamo in 2006. In 2012, he pled guilty to charges related to couriering money for al-Qaeda that allegedly financed the 2003 Jakarta hotel bombing, in which a number of people died. The good news for Mr. Khan is that his agreement could result in his release as early as next year. The more troubling news, however, potentially for the rule of law, is that it requires the defense to request vacatur of a landmark decision that was issued by Judge Watkins, the military judge in his case last year, in which the judge granted a defense motion that requested sentencing credit for Khan's torture, if the torture could be proven. And so the judge actually ordered a hearing on that question and said that he asserted a broad authority for judges to actually devise a remedy when the defendant is tortured. And that, you know, if the torture could be proven, that sentencing credit could be granted. And this relates to something that Andrea raised earlier regarding an apology and a big check. I wanted to sort of end on this question of remedies and accountability, because there hasn't really been any for what are now many well-documented instances of torture. And I'd just like to talk a bit more about that and how that squares with the United States legal obligations under either international human rights law or humanitarian law. And then in this particular case, you know, why couldn't the US government let this one judge's attempt to fashion a sort of oblique remedy in one case stand?
Let me just make a real quick comment. What Judge Watkins did, that is a very military judge thing to do. And I mean, that is right out of UCMJ practice that I know and miss so very much. And that is, if the government did something wrong, then there's going to be a remedy for it. And that remedy is probably going to be some effect on sentencing. And that's why that goes back to what I said. From what I know of the cases, I did do a prosecution assessment of KSM. And it was one of the last things I did in the military commissions. If you go Article 3, my assumption has always been the biggest risk would be that an Article 3 judge says, you know what, the death penalty is off the table because of his maltreatment. But I just did want to give a shout out for Judge Watkins, and that is a quintessential military judge thing to do.
Thanks, Stu. That's a really helpful insight. Andrew, I don't know if you wanted to pick up on your comments on accountability and remedies a bit more if anyone else wants.
Sure. You know, I don't want to comment on the specific details of that case because I think that Khan and his lawyers have probably made the best decision, you know, they could make in those circumstances. But it just highlights, you know, to bring us to pop culture. I was thinking about the Britney Spears issue that came out with the IUD and this tremendous amount of control that the conservatorship places on her, even her body. And that decision just reminds me of how much part of what detention at Guantanamo and the black sites has been about. The goal was always complete control over the detainee. Sometimes it meant controlling when he ate, when he went to the bathroom. In this case, this was an additional form of manipulation. And he probably, you know, did what he had to do to get the outcome. But this was another example of the government asserting control over him and manipulating what his choices were, really taking away free will. It does leave the other cases in this situation where they don't have this better ruling to rely on. So I certainly hope that other judges would make similar decisions if faced with that. And I think that's important with respect to how the individual cases are litigated. But there are many, many more people who were tortured or treated inhumanely by US government officials or people working for the US government or at the behest of the US government than the handful who are still in Guantanamo. None of those detainees have received any form of compensation, any apology, you know, US government funded torture treatment programs, and almost no one has been prosecuted, even though there are very detailed records that are available to US government prosecutors, to the ICC, The US continues to object to ICC jurisdiction in large part because US personnel could be subject to prosecution for the same torture that we were talking about right now, though just a sliver of it, just the part that occurred in Afghanistan, not that occurred in some of the other countries. Nancy had mentioned some of her cases in the European courts where there have been these attempts to provide some form of accountability. But accountability is sadly a long-term project. I don't think it's over, but it might be another 20 years before we see a really solid reckoning, before the history books look back on this time and acknowledge the really horrific abuse perpetrated by the US government, created by the US government, implemented around the world at the behest of the US government. And that it's taken decades for apologies for Japanese Americans, for example, who were detained in horrible but significantly better conditions than at Guantanamo. So I think we have maybe a couple more decades before there's a real reckoning, and that's really a tragic shame for the individuals who have suffered during that time period.
Nancy, I saw you come off mute. Did you want to add something?
Well, yeah, we did get some amount of accountability from the European Court. 2 opinions. I can't really talk about them, but the countries' names are still classified and I can't remember their code names. But the European Court of Human Rights gave our client, Ibrahim al-Nasri, 100,000 euros in each case that went to his family. We're about to go to a 3rd country, codenamed Violet, where the court has already ruled basically that everything that we've said happened. It's just a matter of our being able to prove that our client was there. And those opinions are worth reading because they do have accountability. But, something struck me, and maybe this is just my kind of down in the dirt criminal law sort of thought, but the US is making this position that it doesn't have any of these international law obligations, that we're a confined little place here. And yet it will prosecute for money laundering if it has a valid money laundering, or maybe it considers valid money laundering, any case where the money turns into dollars, anywhere in the world, money turns into dollars, we can get you for money laundering. And, it's basically speaking out of both sides of its mouth, which we know this government does and has always done. But I've always found that an ironic decision. And now we have a military judge who just ruled that torture can be used in pretrial cases, an astounding opinion that we will soon, we've already appealed to the commission appellate court, and when that fails, because that court is pretty much a rubber stamp, we'll be back in federal court again, and the cases make no progress. So it's a real tragic situation when you consider the lives of those people. You consider Mohamedou's lives torn apart that should never have been torn apart, and people tortured directly by the United States government.
Thanks so much, Nancy. Well, that's a very sobering note and thoughtful note to end on. Unfortunately, we're out of time. I just wanted to extend one more sincere thank you to all the panelists for coming together to discuss these important issues today. I think this was a really fantastic, insightful discussion, and I do hope that someone from the Biden administration was listening and taking notes, or that they'll listen to the recording, because I think there were a lot of very good, thoughtful suggestions for how to move forward discussed today. I wanted to make a quick announcement. The distributor was kind enough to send me a very large number of copies of the movie, which will be available at Tiller House. So once things open up again, if you haven't seen the movie and you would like to, I think ASIL is going to arrange it so that you could stop by and pick up a copy of the movie to view. So again, thank you so much to all our panelists. Thank you, Gabor and Parker Reynolds, for your question. Thank you to all the audience members, and I hope everyone has a good afternoon.
Thank you.